Good morning. I'm Shivaji Shiva. I'm a charity lawyer, a charity trustee, and a partner in the charities team at VWV. Thank you for joining us today to discuss equality, diversity, and inclusion as they affect charities. As many of you will know, it's a year today since the horrific death of George Floyd. That death was sadly not the only one of its sort, but it may have unique consequences. In the years since, we've seen protests and a number of initiatives seeking systemic change. Those initiatives extended beyond Minneapolis, where Mr. Floyd died, beyond the United States, and beyond the behavior of police officers such as Derek Chauvin, the man who kneeled on George Floyd's neck for several minutes, even as he complained of breathing difficulties, and who was convicted of murder in April this year. The killing of George Floyd sparked worldwide protests against racism. And during the past year, charity leadership teams have spent a great deal of time reflecting on what their organizations can and should do to tackle racism and wider inequalities in the charity sector and society as a whole. This is not, of course, the first time that issues of discrimination and diversity have been considered by the charity sector. Complaints have been made about the lack of diversity among charity trustees and staff since the days when I could expect to be the youngest person in the boardroom, as well as the only person of colour. To take just three, in 1993, Third Sector magazine reported in a piece called The Great, the Good and the White that only 2% of voluntary organisations in England and Wales had a black trustee. In Building on Trust, their 1995 study of trustees for NCVO, Naomi Sargent and Kate Kirkland found that the stereotype of trustees being white, middle class, middle-aged, and male is largely true. And then in 1995, Andrew Hind concluded in the book from which I drew the above examples, or the previous examples, The Governance and Management of Charities, that one is forced to conclude when faced with the evidence that the voluntary sector has to do better. So, has anything changed? I think it's only right to acknowledge that there has been some change over the decades since those statements were made. The charity sector certainly feels like a more diverse place than it was then, but the pace of change has perhaps been slow. Perhaps the tone has now changed. There's certainly a sense of urgency in some quarters, at least for now, and many organisations have published ambitious, aspirational statements about their commitment to make our society a better place. And they're beginning, we hope, to develop the action plans necessary to make those aspirations a reality. But then there was a good deal of urgency about protesting campaigns in the 90s, in the 80s, and though I can't claim to remember it before that. And of course, some charities have been actively campaigning for change across those decades. The race equality think tank Runnymede Trust was formed in 1968. Stonewall, the largest LGBT rights charity in Europe, was formed in 1989. And of course, and alongside that active campaigning, many charities have been working quietly to tackle discrimination in their particular fields. Yet, decades later, we're still forced to conclude that the voluntary sector has to do better. It's not yet clear whether the attention these issues have enjoyed over the past year and continue to enjoy will be sustained for long enough to deliver the fundamental change that's needed. Boards will differ in how far they feel that their charities have a role in that process. But what feels clear to me from the client calls I've taken over the last 12 months is that many people working in or interested in the sector have been led to expect real change. And while today is a day on which many people will be focused on racism, the need for change extends beyond issues of race. We've seen recently the death of Sarah Everard and the Everyone's Invited campaign, highlighting the continuing need to tackle sexual violence and the banter or other behaviours which can enable it. The challenges of COVID-19 and its different impacts have highlighted some troubling attitudes to age and to disability. And of course, there are other similar discussions to be had about the other protected characteristics under the Equality Act and about characteristics which are not among the 9 listed in the Act, including class and social background. These topics present real challenges to charity leaders. Trustees face urgent demands from employees, volunteers, and the people their charities support. Demands for more representative leadership teams, whether as trustees or executives, demands for engagement with staff and service users, demands for a new language, and sometimes ill-focused demand for real change. This desire for change is clearly a positive thing, but it can have difficult consequences. We've seen over the past year people losing roles as trustees, as chief executives, and as volunteers. And recent developments suggest that the pressure is not letting up. So charity leadership teams face the challenge of seizing the opportunity to deliver change that some organisations have aspired to for years, while managing the pace of that change to avoid unanticipated consequences and ensure that charities continue to deliver their core purposes. Just how difficult that can be was, I think, highlighted during the last week with the publication of a 108-page report by the barrister Akua Reindorf into the circumstances surrounding two events involving external speakers at Essex University. Now, our session today isn't going to extend to talking about issues of free speech, but what was interesting there was that you had a university working hard to do the right thing in response to the concerns of its students, which nonetheless had to go through a process of over a year, deal with a 108-page report, and see itself criticised, at least in part, for engaging with Stonewall to try and ensure that its work met the highest standards in relation to equality, diversity, and inclusion. And that report concluded that there had been breaches of individual rights. So we know it's complicated. And while the position of charities will differ, all trustees should be considering these issues. Otherwise, they may be ill-equipped to respond to demands for action from the charity staff or the people it serves. And we hope that this webinar will help with that process. I hope that tells you a little bit about why EDI is on the agenda in our view. We're going to go on to briefly touch on the language you're using and what we mean by EDI, and then move on to talk about the legal framework and look at different particular areas of activity, focusing on HR and staff, operations and the people supported by your charity, and then governance. We'll then come back to responding to allegations of breach, and we're hoping to keep between 10 and 20 minutes to deal with some questions. Really quickly, I just wanted to share with you 3 slides for brief inspiration. This is the Joseph Rowntree Charitable Trust, which engaged really positively with its history, with links to slavery in its work. And interestingly, as well as making a positive commitment to addressing those issues, has committed to developing a longer-term plan, including, intriguingly, restorative justice. So quite an exciting example of work being done in the sector on EDI. Next slide, please. Against that, there's a note of caution with the National Trust, in an example that many of you will be familiar with, seeing a regulatory compliance case opened by the Charity Commission after it published a report examining links between its properties and the histories of colonialism and slavery. That happened despite the fact that before issuing the report, it had consulted up to 2,000 of its members, and might have had something to do with a letter written by a group of 20 MPs and peers to public newspapers. But in any event, I'm sure that many charity trustees will have seen the headlines attracted by that inquiry and felt just a little bit cautious about what the impact on their charity might be of similar work. Next slide, please. Against that note of caution, it was interesting to see Runnymede Trust responding to a very similar instance very firmly. So the Runnymede Trust had responded very carefully to the Sewell reports on racism earlier this year and provided detailed criticism of that report. In response, there was then a similar letter by MPs and a suggestion that the Charity Commission would be examining the work of the Trust. I think the statement that the Trust issued is a really positive example of a charity having carefully thought through its position on these issues and being willing to defend the governance approach it had taken. Next slide, please. So in these 3 slides, I just wanted to summarize briefly what we mean by equality, diversity, and inclusion. First, equality. which we're taking to mean equal opportunities and fairness for all. We mention it in part to say that while there is an active debate about the difference between equality and equity, whether we start from the same place or need to recognise that people may be starting from different places, we're in this session using the term equality. Next slide, please. Diversity, and here you see the definition there, and the focus on recognising the benefit of a range of perspectives to the work of a charity. Diversity of thought, in other words. Next slide, please. And inclusion, where the recognition that there's a need to go beyond merely being open to diversity and equality, but actually welcoming that process and taking steps to ensure that changes made are embedded. Next slide, please. So in considering all of these issues, charity leaders will need to keep under review the charity's strategy on equality, diversity and inclusion, and bear in mind the high level of public expectation and close regulatory scrutiny on organisations looking at these issues. In doing that, they'll need to bear in mind the Charity Commission's guidance on decision making for charity trustees and the usual framework of responsibilities outlined in CC 27. So it's Charity Commission guidance CC 27. They'll also need to consider the Equality Act 2010 and what that says about responsibilities to the individuals involved with the organisation. And then in relation to the duties of care that charities have to all of the individuals they come into contact with, in accordance with the Charity Commission's guidance on safeguarding, they'll need to consider both their contractual duties and their duty of care in negligence. So now I'm going to hand over to Kathy, who will speak further about the legal framework for these matters.
Right, good morning, everyone. As Shivaji said, I'm an employment lawyer, and I am going to be talking a bit more about Equality Act and the legislation that protects your employees. So the Equality Act has been in force since the 1st of October 2010, and it consolidated and replaced all the existing discrimination legislation that existed. There were 11 acts at the time, dating back to 1975 with the Sex Discrimination Act, and 1976 the Race Relations Act, and more recently sexual orientation and age discrimination regs in 2003. In overview, it protects against direct and indirect discrimination, victimization and harassment. So these are general prohibitions that apply to all the protected characteristics. And it sets out details of the 9 protected characteristics, which we're going to look at in a moment. As we've just highlighted there, I'm going to concentrate on Part 5 of the Equality Act, which relates to employment protection, but Part 3 also covers services, and similar principles apply to those. The Equality and Human Rights Commission state that it's the legal framework to protect the rights of individuals and advance equal opportunity for all. Next slide, please. So we've listed there the 9 protected characteristics. So I suppose what it's worth remembering is that discrimination isn't in itself unlawful unless it relates to one of those protected characteristics. So for example, if I have a prejudice against people who wear red, then I can refuse to appoint them, refuse to promote them on that basis, and it might raise other issues of fairness, but it wouldn't be discriminatory. So age, of course, protects people of any age, so both older and younger people. Disability covers both physical and mental health. Then we've got gender reassignment, which is quite prevalent at the moment in terms of claim history. Marriage and civil partnership, which is much less in the news at the moment and produces fewer disputes. Pregnancy and maternity, still legislation going to protect pregnant women in particular. Race, which obviously is very much in the press at the moment. Religion and belief, sex and sexual orientation. And the only other thing I wanted to highlight here was that these rights are not absolute. and often they come into conflict. So, for example, religion and belief can be opposed in some cases to sexual orientation protection. And some of the cases and the disputes arise relate to strongly held and opposing views in relation to each of those areas. And likewise, there's been some public debate about transgender as opposed to women's rights, and the opposition between some of the protections that people feel ought to be afforded to people with those protected characteristics. Next slide, please. So we know who's protected. What are they protected against? Well, direct discrimination is the sort of does what it says on the tin. You know, you can't discriminate against me because I'm a woman. You can't refuse to promote me because I'm a woman. It's a protected characteristic. Indirect discrimination is much more nuanced and prevalent. So this is where a provision, criterion, or practice applies, which has an adverse impact on a group of people who share a protected characteristic. And a common example, again, gender related, is if you require individuals to work full time, then that is likely to have an indirectly discriminatory impact on women, because statistically at the moment, they still have a majority of caring responsibilities. So they are not able to meet the requirement to work full time. We then have two types of discrimination that only relate to the disability protected characteristic. So that's discrimination arising from disability. And that would be, for example, where, well, the EHRC website gives an example where an employee is not allowed to be paid a bonus because they've had a lot of time off for treatment for their cancer. So they have a disability. The reason they're not getting the bonus arises from their disability, and that again is prohibited. And the last one on the slide, the failure to make reasonable adjustments. This is a positive obligation on employers, which only relates to disability. And this is the obligation where somebody suffers a disadvantage because of a disability to make an adjustment in order to ensure that they're on a level playing field, really. So you take away the disadvantage by making an adjustment to working conditions. So, for example, a braille typewriter for somebody with visual impairment, or it could be something more nuanced, like somebody with an illness that means they get very tired quickly. You might need to offer them reduced hours in order to make an adjustment to enable them to perform their role. Next slide, please, Emma. We then move on to harassment, which applies to all the protected characteristics. So a person A harasses person B if A engages in unwanted conduct which has the purpose or effect of either violating B's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. So a couple of points here. It doesn't have to be intentional. It has the intention or effect. So it's in the perception of the person who receives the harassment, although there is a reasonable and objective nuance to that. Your starting point is if the individual receives it as harassment, then it will be considered harassment. And the second thing is a one-off incident can in itself constitute harassment under the legislation. It doesn't have to be repeated, or somebody doesn't have to indicate that their intention is unwanted. And harassment under the legislation comes in two forms. So it's a harassment in relation to any protected characteristic, and then separately there is protection against sexual harassment. So that's conduct of a sexual nature, such as sexual innuendo or physical contact. Next slide, please, Emma. And the last general form of prohibited discrimination is victimization. So this would occur where a person has brought a tribunal claim, perhaps, or supported somebody to bring a claim, or more commonly in employment circumstances has perhaps raised a grievance. And then because that grievance or complaint relates to a protected characteristic or other actions under the Equality Act, they suffer a detriment as a consequence. So this commonly rises where you have individuals who perhaps bring a lot of grievances or complaints. They might bring whistleblowing complaints, they might bring complaints about various matters, and some of them might relate to particular discrimination issues related to a protected characteristic. And at the point that that individual becomes unmanageable because of the numbers of complaints, you know, an employer might want to either manage their behaviour internally or manage an exit, but that can constitute victimisation to that individual. And we are actually seeing an increasing number of claims for victimisation at the moment. Next slide, please, Emma. So there are certain exceptions to discrimination law in the Equality Act where it either doesn't apply or it may be lawful. I'm not going to pick up on them all. Some of them are very specific, for example, national security and armed forces. And the charity exemption relates primarily to public benefit, although of course it does overlap with employment to a limited extent. But I did want to pick up on the general occupational requirement. So there are a few types of role where it might be a defence to discrimination because the nature of the role or the work is such that having a particular requirement, particular characteristic is a requirement for that role. So, for example, more traditional theatre companies might require a man for a male role or an older person for an older role. I also wanted to pick up briefly on the organised religion exemption. So this would apply, for example, to a religious leader where holding a particular religious belief is a requirement for that role, but it wouldn't, for example, apply to a geography teacher in a religious school where actually it's not required to actually hold particular religious beliefs. And the other one I just wanted to pick up a bit, because again, it relates, it does cause some confusion, is the requirement for positive action. Next slide, please, Emma. So general positive action measures are permitted with the aim of improving equality for underrepresented groups who share a protected characteristic. And these actions are allowed in two circumstances. So as an employer, you can take proportionate measures to enable or encourage equality. Now that could be, for example, in encouraging engagement with local communities who don't see you as an employer of choice. It could be advertising job vacancies in particular publications so that you get a wider range of applicants. It could, for example, be mentoring schemes for people sharing protected characteristics within work to support them in applying for promotion. So it's targeted at people with protected characteristic, but with a view to improving equality within your organisation. And the second place you can take positive action is in relation to recruitment and promotion. And this is where if you have two candidates for a role, both of whom are as qualified, so they both come equal first in a recruitment process, then if you have one with an underrepresented protected characteristic, you can prefer them over the other, but only in that very, very limited circumstance. What you cannot do is say, actually, we want more Black leaders in our organisation, so therefore, even though our objective recruitment process they've not done as well, we're going to appoint them anyway. That would be positive discrimination, and that is unlawful. Next slide, please. So we've talked a bit about some of the exceptions to discrimination law. Objective justification is probably the primary defence to a claim of discrimination that most employers use. It's a defence, is not a defence to direct discrimination other than in relation to age discrimination. It only can be used as a defence to indirect discrimination or to discrimination arising from disability. And this is where that an employer can prove that they have a good business reasons for its decisions, which relate to that protected characteristic, and that the discrimination is proportionate, appropriate, and necessary. So it's proportionate, as in you balance the needs of the employer against the discriminatory impact on the employees, and you look at whether the way that you're addressing that business need is the best one in the circumstances. So you try and minimise the discriminatory impact. So an example of that, we've said full-time employment might be potentially indirectly discriminatory on grounds of gender. If, however, there was a need for people to work full-time that could be justified, so for example, there was a transport requirement, the work was in a remote location and you had to fly people there, then you might say actually it's not practicable for people to work part-time, and that would be an objective justification. Next slide, please. So where do you have to bear in mind the wider EDI issues? They sort of happen throughout the employment relationship, from recruitment to termination. So obviously in recruitment, you need to have objective grounds for recruiting people that are justifiable and consistent, and you need to make sure that your recruitment criteria are not indirectly discriminatory, unless, as we said, they can be objectively justified. But generally speaking, there shouldn't be a need for indirect discrimination. The same sort of criteria would apply to opportunities for training and opportunities for promotion, that you need an objective way of assessing promotion opportunities in particular, and it shouldn't be linked to requirements that are harder for people with protected characteristics to fulfill. Equal pay was the first discrimination protection in the UK in 1970. We first had the Equal Pay Act, and there still is a gender pay gap. You'll be aware that larger charities have the obligation to undertake gender pay gap reporting, and there was a proposal in the last Queen's speech to extend this to the racial pay gap as well. Religious beliefs and practice, just be aware, during employment, things like dress code and timetabling of breaks and things like that, and requirement for working hours need to be flexible and to fit people from diverse backgrounds. It's very easy, isn't there, to apply our own criteria of what's acceptable and normal. And if we have if our leadership team's not diverse, then actually those criteria of what's acceptable and normal might be very narrow and limited and not actually objectively justifiable. So, the more diverse our leadership teams are, the more diverse our dress codes, our flexible working arrangements, and our codes of conduct and unacceptable behaviour criteria might be. So watch all of those during employment to make sure that you really are an inclusive workplace, and that people do not feel unwelcome or not included because of particular procedures or policies or requirements within the workplace that actually are not necessary. And then the last area where discrimination can occur and almost always leads to a claim is the dismissal of staff. You need to be able to show that the reason for dismissal is fair, objective, and it's consistent, because otherwise there is a risk of a discrimination claim if the person who's dismissed has a protected characteristic. There's an inference that if there's not an objective and fair reason, it can be linked to a protected characteristic. Next step, please. Next slide, please. So the last slide, we're just going to look at a few practical steps. It's sort of the very, very basic is having an equal opportunities or an equality, diversity and inclusion policy and a dignity at work policy. But there's no point in having one and then filing it away on the shelf and never looking at it again. It has to be embedded in your organisation and inform the way that people act, as well as all your other policies and procedures. So you need to check your other policies and procedures for consistency on your overall EDI strategy. Many organisations are now having workplace champions. Many of you may have, for example, mental health champions at the moment, and also specific mentoring schemes to support people with protected characteristics and ensure they have access to promotion and issues like that. It's worth really considering carefully how you address issues, whether that's by way of a formal grievance procedure, an informal grievance procedure, or whether you are creating safe spaces for discussions to occur, particularly if you have rights-conscious employees who perhaps have deeply held but contradictory views. It's important that differences aren't allowed to fester and become inappropriate and lead to proper disputes. So how can you frame those debates in a sensitive and supportive manner to allow those diverse views to be expressed in a courteous and respectful way? And where grievances and issues do arise, have you got workplace mediation? Have you got an effective grievance procedure to address them? Training, there's been a recent case, many people train on EDI at the beginning on induction. There's no point doing that and then leaving it. A recent tribunal case found that unless the training was current and was effective to prevent discrimination, then it wasn't adequate, wouldn't provide a defence to an employer. against a claim for discrimination. So your training needs to be refreshed and constantly renewed. And then lastly, there's a big debate about whether having statistics and monitoring them is helpful or not. I suppose what I would say is, if you have an EDI strategy, work out how you're going to assess the effectiveness of that, and think about what statistics or information you need to obtain and review in order to help you establish whether your strategy is working. So there's no point taking the statistics and not using them, and some people do find it difficult to disclose information. Just before I finish, I would like to say I've said that, you know, discrimination is only protected legally in a certain framework. Obviously, in all of our organisations, inclusivity and embracing diversity is a much wider issue than that. And I think Shivaji said earlier, you know, the 10th protected characteristic, which isn't protected yet, but is much more in the public debate at the moment, are deprivation by way of socio-economic deprivation. And, you know, that affects people from different ethnicities. It affects young people in particular. So I suppose if you're looking at widening your diversity and inclusion debate, then that would be the 10th protected characteristic I would look at. Now James is going to talk to you about some operational issues.
Good morning, everybody, and thank you, Kathy. So, as both Shivaji and Kathy have pointed out, you know, there are some very specific legal issues around EDI, and those are the protected characteristics of the protections set out in the Equality Act. It's part of a much broader discussion, and as charities, I think it's helpful to think of it both in terms of your specific statutory legal duties when you think of something like the Equality Act, but also your more general duty to safeguard all of those that you deal with as a charity. And this really is where, when we start to get to the coalface and think about what this looks like in day-to-day practice, and also I would say that the context of some of what I'm saying is also about understanding and managing risk. We can examine how some of these issues will impact and what you can do to address them. So there is certainly at the moment some increased regulatory interest around these issues, and there is bound to be. I mean, regulators are to some degree always going to be political creatures insofar as they will reflect the issues that are prominent and seen as important issues of the day. So I think it is worth bearing in mind that when you're thinking about the sort of risk management dimension, and perhaps the thing people will think about most readily is that there is, with greater public awareness and more discussion and focus on these issues, there is also going to be a hugely increased awareness and focus on it by the people that you are dealing with as an organisation each and every day. And that will lead to, and certainly has in our experience, led to significantly more complaints and claims around these types of issues. And to give you a few examples, and this really, for me, I mean, some of these examples I think illustrate how the types of complaints that you might face as a charity go beyond the sort of hardwired legal protections of the Equality Act. So an example was a charity fundraising endeavour to based around some artwork, and there was a complaint raised essentially that the nature of the artwork amounted to cultural appropriation, and that was considered to be quite offensive. Another example that we would see, it was a charity offering a sort of temporary accommodation for vulnerable families, and they were grappling with some difficulties that had arisen, in particular with service users who also had mental health issues, and how they would balance the need to have safe arrangements along with their duty to make reasonable adjustments for vulnerable families and those with the characteristics of disability. And I think it is sometimes forgotten or overlooked that mental health conditions, including in some instances addictions, can be disabilities, and therefore give rise to the right, the duty to make reasonable adjustments as well. Another example of how you can inadvertently, and this goes to Kathy's exposition of what is indirect discrimination. If you were operating, for example, as sort of a drop-in centre, and you had as a policy that nobody could wear any head covering, for example, you might find that would disproportionately impact people from certain backgrounds, whether those are along race lines, or perhaps it might even have an impact in a religious context as well. So it's really a question of sort of being alive to how what you do in practice impacts the people you come into contact with, and how it might impact the people you come into contact with. Can we have the next slide, please? Okay, so I mentioned regulatory interest. I mean, what that sort of means in terms of you as an organisation, and what you should be thinking about is as I say, your broader safeguarding duty is about ensuring that your charity harm the people that it comes into contact with. And we've seen the types of harms that can result from discriminatory treatment, and certainly, we have a well-developed conversation now concerning actually just how sensitive some of these issues are, and how deeply impacted the individuals who have experienced discrimination actually feel. So for an example of where a regulatory element may lie here is that where you were facing a complaint of discriminatory treatment against a service user, which is Part 3 of the Equality Act, you would also essentially be saying that you potentially have, in the way that you have dealt with that individual, or in the way that your organisation approaches the provision of services, actually harm somebody. That's the essence of the complaint, and that gives rise to a risk potentially of bad publicity. I mean, we have to, I think, recognise we exist now within an environment with media where actually these things can take on a life of their own and become very public very quickly, particularly if the issues being talked about are issues that are interesting to people. The phrase sort of go viral, I think, probably captures the potential for these things to grow. But also, if you don't engage with somebody's complaint effectively and resolve that in a manner they're happy with, then actually when people are angry, there is a greater risk that they might pursue claims, and you can face civil claims for discriminatory treatment of service users. And so I think there's a worth bearing in mind, and the requirements you will have to make reports where these types of issues arise to the Charity Commission, based on the possibility that they would represent a significant threat, if you will, to the charity's assets or reputation. And where safeguarding is concerned, the Charity Commission guidance encourages immediate reporting. So it's worth bearing that in mind. Now, the Equality and Human Rights Commission is the sort of the national equality body, if you will, and as well as producing a lot of guidance, which is really worth a look. And for those in the charity sector, the core guidance is voluntary charity and community organisations guidance, and it's really useful. They give some work examples, and well worth a read. But equally, they are an enforcement body. They do have specific enforcement powers if they are become aware that an organisation is doing something which is discriminatory. They can serve enforcement notices that require the production of an action plan. And ultimately, if you don't comply with it, there are fines as well. So they are a body with some teeth. We have the next slide, please. So I think when you think about the practical steps, it's probably sort of useful to think about, well, as an organisation, if we're dealing with both statutory obligations, but actually these sort of broader ideas and discussions around some of which are quite sort of philosophical about how we should deal with people and how we can have a sort of a fair and inclusive approach. But you will need to set your vision, I think, and values as an organisation, and then see how that trickles down. And it's really about ultimately how those visions and values are embedded in what you do each and every day. And you might therefore want to review some relevant policies and procedures and make sure that actually they're working in practice. Do they deliver, what you're trying to deliver as an organisation? And if they don't, how could they? Reach and accessibility, I mean, I think is about, well, you have objects as a charity, you have things that you are trying to achieve. Is the way that you go about it achieving that, in terms of are you accessing that, the recipients of services that you want to access? Are there any barriers that are preventing you getting a sort of a broader sweep within your target demographic? And again, it's just worth, I think, reflecting on that and seeing whether in practice these things are working. You're providing support, again, I mean, where people do raise concerns, it's quite easy, I think, to sort of fall into a defensive mode and try and justify what you've done, but actually equally recognizing that individuals who are touched by these issues can be deeply affected, and the need to provide support. But part and parcel of it, and the second limb of that is being prepared to take action when it's appropriate. And again, that sort of inclination, I think we all have, to start from the defensive, whereas actually to have an open mind and be prepared to identify where things haven't worked for whatever reason, which doesn't necessarily imply any ill motive, but actually identify those action points and address them with a view to protecting your charity, delivering upon your values, and ultimately, moving to a place where you really do reflect in practice what you would like to. Cultural issues, I mean, this is part of the sort of the vision, if you will, really, which is starting with your statement of intent and thinking then about how you measure in practice how that actually is delivered. And consultation surveys always a really useful way to gauge how things are working in practice. Engage with your stakeholders and your service users, make sure that you sort of understand what is working and what perhaps isn't. So can we have the next slide, please? So where you do get complaints, and I'm sorry to say, I think they are perhaps inevitable in the current environment. I think it's really important to have a complaints process that works. It's accessible. You think carefully about who you want to be able to access that. You provide service users, or actually do you have a general complaints policy that anybody can access? And think about what it is you want feedback on. I mean, complaints procedures actually are not just about people sort of hammering out their own personal grievances. It's a really useful way to gather feedback and an opportunity for self-evaluation to identify those action points. But when a complaint hits, they can be concerning, and I think what we would suggest the starting point would be is, consider the nature of the complaint. Think about it in that sort of risk management context. Is this a complaint about something isolated and nuanced and relatively low key, or does this have much bigger implications? Do you need some professional support? Think about whether or not there's you're going to want to, for example, prepare a press statement if you've got a complaint that perhaps has come from a representative group, and there's a possibility that this is something that can garner a huge amount of publicity, which is a real threat to your reputation as a charity. do you need to notify insurers? I think it's often forgotten that insurances can provide financial support with public relations services, and also with dealing with claims themselves, and sometimes regulatory enforcement action as well. But you will have some specific obligations, and you have to report some claims to insurers, but also circumstances that could give rise to a claim to a complaint will often be your first opportunity to say, well, oh, we can see what's coming down the tracks, and this is something that needs to be reported to insurers. I've mentioned the serious incident reporting to the Charity Commission already. And also just think about, does your policy and the way you go about dealing with a complaint ensure that actually you put yourself in a position to properly consider that complaint and investigate it, and actually does it assure the sort of discretion around that that's going to encourage people to complain and have faith in your complaints procedures? Sometimes these are very sensitive issues, and I think people would be reluctant to engage with you if you felt that their complaint was going to be circulated around the whole sort of organisation. And you have to also build into the process the ability to have that degree of objectivity, so that whoever's looking at the complaint can keep an open mind, and also so that when they are investigating it, other people haven't already got some preconceived ideas or been able to think of ways round that might actually hold a meaningful investigation. Can we move on to the next slide, please? So again, and I've touched upon this. I mean, support for affected individuals. Don't forget about it. It's really important. Ultimately, when you're dealing with allegations, one of your objectives will be to resolve somebody's concern. If you can support somebody who's clearly upset or angry or whatever it might be, that's going to be part of the process of showing that you care. And also getting them to a place where you might be able to move more readily to a resolution. Which policies apply? Who should lead your response? I mean, it sort of does what it says on the tin, but just think about the nuts and bolts of your response. If it raises certain issues, do you have policies that are already in place, and what do those policies say about what you should do? In terms of who should lead your response, that might be directed by policies that you already have in place. It might be a question of working out who is best placed to do that. And I mentioned objectivity. Somebody who is a step removed from the particular issue is always useful, because that puts them in a position to look at it with an open mind. So communications with the complainant and interested parties. I mean, it's worth just always thinking about how you communicate with anybody that has signalled an interest in the particular complaint, because again, this is all about sort of reaching for the objectives of the exercise. What is it that you're trying to achieve? It is about resolving matters. You want to do the best by the person or the people who are bringing the complaint to you, potentially, but also it's about risk management. And sometimes soft communications, just the way you phrase a response, how often you will keep somebody in the loop about what's happening with the investigation of their complaint and when they can expect a response and what that might look like. You'd be amazed how hugely important those things, I think, are in practice in terms of the outcomes of any complaints investigation. So you think about the scope and nature of the investigation itself as well, so that you've got a very clear idea from when you get going about what it is you're going to do and how. And there aren't any absolutes around all of this. You need to do something that's reasonable and proportionate. You need to think about what's actually being complained about. Is it an isolated issue? Do you just need to look at and ascertain what the facts are of that particular issue and provide a response, plus any recommendations for further action? Does it actually reflect that there is something about a process or a system, some way in which you engage as an organisation with your service users, for example, that suggests there's a bigger problem, and therefore would necessitate a slightly broader investigation? Sometimes, if you're being accused of let's take an example of systemic racism, and you want to demonstrate as an organisation a suitably open and rigorous approach to investigating the possibility of that. You could think about whether or not somebody within your organisation who is part of that embedded culture of discrimination, so the complaint alleges, would be the best person to investigate, or in fact, could you look to somebody external to do it? So that's lots of different questions, and we could do a whole session purely on investigation. But it's the key message here is think about what it is you want to achieve and how you should go about achieving that. And this follows to the last point with the terms of reference about scope, how broad you want the investigation to run, and ensure that you're absolutely clear about that from the outset. Otherwise, there is a sort of a lack of clarity and a lack of purpose, which of course I think is going to ultimately be a barrier to you achieving what you're trying to achieve from that investigation. Can we have the next slide, please? So finally, think about your output. This comes back to objectives. You're trying to achieve something by investigating an allegation, and ultimately, you will produce in the course of that investigation a report what has actually happened. That will detail the findings. You produce that in order that you will share it with the person making the allegation. Are you sharing it more widely? Is it something you want to publish? What would be the purpose of doing it? And again, there's no right and wrong answers. It will depend. But think about it case by case. There are good reasons to do different things in different circumstances. It will depend on the nature of the allegation, the nature of who is raising that allegation, and your sense of risk and how best to manage that risk. But these things are worth thinking about. Recommendations and remedial action. If you do identify that there are some issues, the allegations have some substance, what are you going to do about it? Are you going to review some policies? Are you going to ensure there's some training for staff members, or perhaps even disciplinary action against staff members? Follow that through and ensure that actions are taken. And actually, how then ultimately, if you've put in place some recommendations that are looking at policies and procedures, for example, how will you know when that work is done and that it's had the impact that you want it to have? Because those recommendations are driving at achieving something. So think about how you will come back to that in due course and consider it again. And you might have, for example, a subcommittee of trustees that will have that as a standing agenda item, or once every so often. Okay, next slide. Okay, so sorry, that sort of brings my part to a close. So I'm going to hand over back now to Shivaji, who's just going to take you through some of the governance aspects of these issues.
Thank you, James. And thank you for those of you who've put questions into the Q&A box. We're really keen to pick those up to the extent we have time. I'm conscious that we are coming to the close of the time that we've set aside. So you'll be relieved to hear that I've really got 3 things that I want to do in this session before we move on to your questions, which is to outline very briefly the approach we expect trustees to take, point to a few warnings about that approach, and possibly one example. In doing that, I'd like to respond to the question that's about practical approaches to that have worked, and but we'll come to that. So if I say that the approach that we suggest trustees take is to listen, to reflect, and to decide, because we see a number of problems that arise where organizations are in effect bounced into quick decision making. So listen, reflect, and decide. Can I have the next slide, please? And if we move on to the one beyond that. Thank you. In that process of going through, trustees are expected to exercise sound judgment, to avoid undue risk, not to to commit, to put it briefly, and to really consider the risks that their charities face. And you need to be putting into place an action plan that's that it is possible to properly resource so that you can produce the progress that perhaps some organisations have struggled to produce in years past. In doing that, I think there are a number of key warnings, and I'm just going to highlight 5 of them. The first is the push for real ambition that it's hard to meet. And that's summarised in an article in Third Sector today by Sanjeev Lingaya, who marks the anniversary of George Floyd's death by saying we should commemorate that death by choosing life-affirming alternatives to racism. Interestingly, and I'll leave you to read the article, but he goes on to say, ultimately, this requires that charities explicitly write racial justice into their mission statements and make this cause central to why they exist. And I think that would concern a number of trustees in the sense that it requires a swiveling of the cause of their organisation from whatever it may be, relieving poverty, something else, in order to deal with a particular wider and arguably political issue. So, so there's a need to be really clear about what the overall aim is. There's a question about language and scope. We addressed briefly earlier the language that we're using in this session. It's worth noting that Charities So White, the campaign group, has been clear that this isn't a conversation about diversity and inclusion. It is, in their words, a conversation about power and privilege. And they say we speak about and value lived experience over data. Again, many trustees and managers will be unsure how to contribute to a conversation framed in that way, particularly if they don't have lived experience or of discrimination to draw on. And so there's an urgent need to do as James suggests and set up terms of reference that can be agreed for the conversation that needs to happen. I think it was Kathy that mentioned involvement and co-delivery, and there's a real issue about bringing staff and other stakeholders on board so that you can seek to avoid the mission drift that results in overambition and set clear expectations and ensure that those match the expectations of the board, or that the board has taken into account those of other groups. We encounter regularly instances where the high expectations of particular groups within the board, groups within the staff, were not met by the charity concerned, and disputes arose as a result. Fourth piece is what can trustees be doing now, and a warning about just thinking about the timing and how quickly it's realistic to produce decisive, genuine change, and being able to show decisive action without setting expectations that the leadership team cannot then meet. So if I move on then to the tools for that, this slide is about the Charity Governance Code, and I think this is the one that it's worth spending time on. And in the Charity Governance Code, as published in December 2020, as some of you will know, it wasn't fully reviewed, it was just refreshed, and it recommends 4 stages of practice. Thinking about the process, that's the reflecting that we've talked about, setting plans and targets, tailored plans and targets, monitoring and measuring how well the charity is doing, and interestingly, being transparent and publishing the charity's progress. I think that's a really useful tool, and if you don't enjoy that particular framing of it, the next slide sets out an alternative framing by Parry Dillon, who's done a lot of work in this space, and whose article is also highlighted there in the slides that you'll be seeing. And I think in talking to the clients that we've been engaging with around equality, diversity, inclusion, both in relation to race, but also in relation to the wider issues, there's often been a sense of uncertainty about how to set the course. So a genuine and strongly held desire to respond to all that's been going on. I read a survey yesterday that suggested that well over 70% of us have had a conversation with our friends, families, or colleagues over the past year about race following the death of George Floyd, and perhaps, and I suspect there are similar figures for issues of sexual violence following the Everyone's Invited situation. So that there is a widespread desire to create change, but there's often an uncertainty about how to do that. And so treating this as simply as a journey and reviewing the progress and expecting some failure is, I think, a useful model to pursue. It's past 11 o'clock, so I'm going to draw things to a close there by saying I think those practical steps are really helpful, and I hope they provide a framework to some of the thinking that you may be doing. And I know that any of the members of the panel would welcome a conversation about any specific queries that you might have. And I know that that's true for me. So if you want to give us a call and say that you were interested in this session, that we perhaps didn't cover everything that you wanted, then I would certainly be very happy to talk to you about how we might about the specific issues you raise and about how we might help you moving forward. Thank you for your time this morning.